providing a legal limit for the amount of, I got to abbreviate this, THC allowed to be present in a person's blood while operating a motor vehicle. We have a couple amendments to the bill. We're removing the language concerning urine and saliva. And I just got the fiscal note from downstairs, and they will have to redo the fiscal note because it'll make a tremendous change in the note, or in the fiscal impact. And on the last part of the fiscal note, they, I think once we hear the experts' testimony, we'll realize this probably will not increase the effects on local county that much. What I'd like to do, if with your permission, is read a letter from Sheriff Ibsen from Missoula. He was unable to be here today, and then I will turn it over to my expert witnesses.
Okay, and then submit that as part of the record, if you would, please.
I will. I think I have enough copies for the committee. This is from Carl Ibsen, the Sheriff of Missoula County. Honorable House Judiciary Committee Chairman Kearns and members of the House Judiciary Committee. It was my desire to be with you to testify on this impairment bill today, but other demands make that impossible. In Montana and nationally, we find that a large number of impaired drivers are under the influence of alcohol, marijuana, or THC, or a combination of both. Additionally involved can be prescription drugs. Research indicates that approximately half of the alcohol-impaired drivers who kill someone in a wreck are also under the influence of marijuana or THC, creating an even deadlier combination. Such was the case with the young man who killed my wife, Judy Wang, in a horrific crash on I-90 near Warm Springs on 25th of September 2009. Many of you knew and respected Judy. Gets me a little choked up thinking about Judy. And her tireless efforts on behalf of victims of crime, especially domestic violence and DUI. She stood before you to testify on numerous bills and to speak for victims of crime for many years. It was ironic that she, and of all Montana, became victim of one of those impaired drivers that day. In the case of the young man who killed Judy, although his blood test showed a significant level of THC, Montana did not and does not have a specified level set for what amount of THC in the blood constitutes being impaired for the purposes of driving. For alcohol impairment, there are specific levels set, and that is how it should be with THC. House Bill 168 will provide one more tool for Montana and the law enforcement officers of Montana to use in our battle against impaired drivers and the carnage they wreak on society. Please support House Bill 168. Respectively, Carl Ibsen. One other thing I wanted to note before I turn it over is that I brought this bill. It's not pro or against marijuana. It's all about impaired drivers and public safety. And that is my intent of this legislation. Thank you.
Thank you, Representative Moore. Proponents, House Bill 168.
Oh, and I reserve the right to close.
Certainly. That goes without saying.
Mr. Chair, members of the committee, I'm Kurt Sager, S-A-G-E-R, with the Montana Highway Patrol. I'm the State Drug Recognition Expert Coordinator. I'm also the coordinator for Montana's impaired driving programs. Some of my duties as the Drug Recognition Expert Coordinator, I train law enforcement to detect impaired drivers, whether they're impaired by alcohol, drugs, a combination of the both. That is my main job with the Highway Patrol. If we track the news, looking at newspapers, watching the television, it doesn't take long to figure out that DUI is one of Montana's deadliest, if not the deadliest crime. We lose way too many people every year, approximately somewhere around 200 people plus a year to fatal crashes on Montana's roadways. Nearly half of those crashes are caused by impairment, whether it be drugs, alcohol, or a combination of the both. What we've started to see in the last few years in Montana is a significant increase in drug-impaired driving. Our alcohol statistics are staying about the same as far as DUIs go, but our drug-impaired driving is on a significant increase, and it has been for several years now. Marijuana has quickly become the most common drug involved in those drug cases that don't involve alcohol. Some statistics that I have for you that we collected from the crime lab. In 2010, 372 of the blood submission cases that came into the crime lab had marijuana in that sample. In 2011, it rose to 476 cases, and in 2012, it was up to 486 cases. Marijuana has also been involved in many of Montana's fatal crashes over the last 3 years. In 2010, 53 of the fatal crashes that occurred in the state of Montana had marijuana on board. In 2011, that number dropped down to 35 of the fatals. In 2012, it was back up to 45 fatals that had marijuana on board. To kind of reiterate what was said before, this bill is not targeting medical marijuana users or even people who use marijuana at their homes, wherever it is. This bill targets people who choose to use marijuana and then drive. It's not safe to do so. It's no different than our per se alcohol law. We don't target people that drink alcohol. We target people that drink alcohol and then drive a vehicle. It's to protect Montana's motoring public. Marijuana is dangerous for driving because it causes impairment in many, many ways. One of the most dangerous portions of marijuana in driving is it causes a person to have a poor perception of time and distance. Time and distance are two very necessary skills. Judging time and distance are two necessary skills that we have for operating a vehicle safely. You have to be able to judge the distance between you and the car in front of you, when you need to start slowing down for the car that's in front of you stopped or the corner that's coming up, that sort of thing. Inability to divide attention. Driving is the most intense divided attention task that we do on a day-to-day basis. Our attention is required to be divided many times when we're driving. Most of us have all been driving for a very long time. We kind of take that for granted. But if you start thinking about all the things that you have to concentrate on, your gas pedal, the brake pedal, turn signals, turning, monitoring traffic that's around you, your surroundings, the roadway conditions, climate control, the radio, all the stuff that comes into driving, you have to be able to pay attention to every single one of those. Impairment causes people to not be able to divide their attention, and marijuana is no different than the rest of the drugs in that aspect. Marijuana is also known to create a brief attention span in many people when they are under the influence. That's important for driving because if you are concentrating on a task, you have to continually concentrate on that task and all the other tasks that are involved in safely operating a motor vehicle. We see poor performance on the psychophysical tests, the tests walk and turn and one-leg stand that I'm sure we've seen either somebody conducting or we've seen on television. That's how law enforcement officers determine impairment in individuals. The poor performance on these tests isn't necessarily because they have balance problems as much as it is those are divided attention tests that we use to help establish their ability to operate a vehicle safely, and they have the inability to divide their attention and do multiple tasks at the same time. Another issue that arises with marijuana that may not be quite as much of an issue at night is marijuana is known to dilate the pupils. And where this is significant is if you are on a bright sunny day and your pupil is dilated, I'm sure a lot of us have had our eyes dilated at an eye doctor. They give you those really cool looking black shades and you go outside and it's still too bright to see. If your pupil is dilated, you cannot see during daylight hours near as well as you should. At night, that doesn't seem to be an issue. However, another condition that is present with marijuana impairment is a condition called rebound dilation. When a bright light is introduced to that pupil, it will constrict like a pupil normally should. However, it continues to pulse until it goes back to that full dilation, allowing too much light in. Where this becomes dangerous at night is as a car is approaching. I'm sure we've all been blinded by lights, and every light is too bright that's coming at us. The pupil will temporarily adjust to the size that it should to allow that much light in, and then it continues to blow out, and by the time that vehicle meets the person that's under the influence of marijuana, their vision is extremely impaired because the pupil is dilated once again. Some issues that we run into as law enforcement officers when it comes to marijuana impairment is marijuana impairment does not generally cause the person to act like the fall down drunk, for lack of a better term. I'm sure many of us have seen that, where a person cannot even stand up and walk. That's generally not the type of impairment that we see. Impairment is very present, but it is not nearly as noticeable. And some of the impairment, it takes specific law enforcement training, more detailed training, such as drug recognition experts, to detect that. While the officers are good at detecting that the person is not acting normally or as they should, oftentimes it's difficult for law enforcement to establish what it is that is causing that impairment without very specialized training. One thing that I'd like to bring up, you may hear some testimony, I've heard this several times, that marijuana actually causes people to concentrate better on driving. Okay? I will agree with one aspect of that. It allows those people to concentrate on one aspect of driving much better. But we have already established that driving is a very intense divided attention task. And while they may focus on that one aspect very well, such as driving 65 at night on a 2-lane road, they are not concentrating on driving in their lane. So they are driving 65 miles an hour as they should in both lanes on the highway. Or they're concentrating on driving straight, however their speed is varying from 25 to 85 miles an hour. It's the lack of ability to divide attention. People who are impaired by alcohol display the same signs and symptoms. My experience with THC and people under the influence of THC, I've been directly involved in 30 drug influence evaluations on people under the influence of marijuana. The blood tests on those cases have come back with anywhere from 4 nanograms of active delta-9 tetrahydrocannabinol, which is the ingredient that causes impairment in individuals who have consumed marijuana, all the way up to 27 nanograms. In each one of those cases, all 30 of those cases, through my training, it's easy to recognize the impairment. They show very, very noticeable signs of impairment. Some other issues that we're running into, as was brought up, is the combination of marijuana and other drugs. If you start combining drugs, and marijuana and alcohol is a very, very prominent combination in the state of Montana and nationwide, it causes the effects of both drugs to be magnified. So you can have a low-level marijuana and a low-level alcohol, and the person can show very, very gross impairment due to the combination of those two drugs. As a law enforcement officer, it is my duty to protect and serve the citizens of the state of Montana. And being a highway patrol officer, my duties are most geared towards people who motor up and down Montana's roadways. This bill will be very beneficial to us as law enforcement in protecting Montana citizens against impaired drivers that we may otherwise be missing, or we may not have the tools to prosecute them and remove them from the dangerous practice of driving under the influence. I've got a chart here that I'm going to send out around. I've got enough copies for everybody, I believe. One of them shows the average THC level of DUI cases in Montana, as reported out by the Montana Crime Lab. The other one shows the 7 categories of drugs that we deal with as drug recognition experts and the occurrence of those cases from 2007 to 2012. This bill will be a great tool for law enforcement, prosecution, and for protecting Montana citizens. I support this bill. Thank you.
Thank you, Mr. Sager. Further proponents?
Good morning, Mr. Chair, members of the committee. My name is Michael Collier. It's spelled C-O-L-Y-E-R. I'm the detective captain for the Missoula Police Department. I'm also a drug recognition expert and a DRE instructor. I have been since 2002. Knowing Trooper Sager would give you good detail about impairment and statistical background, my purpose isn't to just come up here and repeat that, but I'd just like to speak briefly and anecdotally about my support for this bill through my experiences as the detective captain and a DRE. In the last 3 years in Missoula, we have had over 300% increase in DUI-related offenses involving marijuana, cannabis. As a DRE, I've evaluated a number of people who have been impaired by cannabis in the past. As Trooper Sager says, the impairment to me as a DRE is obvious. Unfortunately, there are a limited number of DREs available throughout the city of Missoula, the state of Montana, to recognize that impairment. That's where a per se level for THC becomes very valuable. As a detective captain, I've been involved in 2 investigations in Missoula recently of fatal car crashes, both of which the driver causing the crash had the sole intoxicant in his system of THC. It was not alcohol related, it was not prescription drug related, but it was straight up marijuana impairment that caused the crash. The department in Missoula works strongly or works hard to enforce the DUI laws, but when we're seeing the rapid increase in marijuana-impaired drivers and with a limited number of DREs to address that, the per se level for THC would be very valuable, just as it is for prosecuting the alcohol-impaired drivers. So as a member of the Missoula Police Department, I ask for your support in this bill. Thank you.
Thank you, Mr. Collier. Further proponents?
Mr. Chairman, members of the committee, my name is Sarah Brasseth, spelling Braseth, and I am a forensic toxicologist with the Montana State Crime Lab in Missoula. I have been there for about 5.5 years, and for about 4 of those years, my main duties have been to test all the blood samples that we receive for suspected marijuana impairment or that have screened positive for suspected marijuana for THC levels in the metabolite THC-COOH. Just a brief background, Kurt Sager mentioned it briefly. THC, when I'm referring to THC, it's the delta-9 tetrahydrocannabinol, which is the impairing compound in marijuana. And if I'm talking about the metabolite THC-COOH, that is the inactive metabolite, so it's what the body is converting THC into to get the drug out of a person's system. And that by itself does not cause impairment. It just shows past use. I was going to briefly kind of run over what other states have in place for THC per se DUI laws to kind of give you a background that this has kind of been a subject of debate in other states and in the field of toxicology. There are currently 15 states that have a THC per se DUI law. 11 of those states have a zero tolerance, so any amount of THC that is detected in the blood would be under this per se. Some of these states also have a zero tolerance for the metabolite, so any level of that's detected in the blood would be under this per se law. One of these 15 states has a per se law for the metabolite level in urine, and I'll kind of come back to that. 2 states, Nevada and Ohio, they have designated a level of 2 nanograms per milliliter of THC in the blood as a per se level. In these 2 states, you can have a per se level in the blood, and they also have a per se level of the metabolite that can be present in the urine that they also use for per se, and they also have a per se level for the metabolite in the blood that can be used for per se. So they kind of have a level for THC in the metabolite in the blood and also for the metabolite in the urine. The problems with some of these laws, including the metabolite, like I said before, the metabolite is not the active ingredient in marijuana, so that by itself isn't indicating impairment. So it's important when looking at per se laws that we include the THC in the blood. Another issue with some of these laws that include the urine metabolite level is that the urine metabolite can be detected longer for extended periods of times in heavy marijuana users. So if you're prosecuting somebody on a per se urine level, you may not be exactly prosecuting people who are impaired. You're just people who have maybe used marijuana in the past. So a recent state that's come up with this is when Washington State legalized marijuana. They came up with a per se level of 5 nanograms per milliliter in the blood. And like I said before, blood is the preferred specimen for DUI cases when drugs are suspected. Currently, blood THC concentrations are the most meaningful indicator and testing parameter for impairment by marijuana. So then the debate becomes, what level should we set as a per se? As I said before, you see different varying levels. Some states have a zero tolerance. Nevada and Ohio have a 2 nanogram per milliliter level. Washington just implemented a 5 nanogram per milliliter level. And Colorado may soon follow with a similar level. So some issues to look at when talking about what should we set this level at. You have to look at if we set the THC level in the blood too high, we may be excluding individuals that are likely impaired at low levels of THC in combinations with other drugs and alcohol. As was currently mentioned by the previous speakers, the combination of THC and alcohol produces severe impairment and is pretty significant. And so if you set the THC level too high, you're going to be excluding individuals impaired at lower levels of THC. How this is impacting in Montana, as Kurt Sager said, so far in 2012, we had seen 486 total cases involving marijuana. Out of those cases, 218 involved just THC and alcohol, so no other drugs were present, and out of these cases, THC was present with alcohol. Out of these 218 cases, 39% were involved in a crash, and 19 out of these 218 cases were fatalities or had a fatality involved. So we're seeing in Montana there's a high prevalence of people that aren't just driving under the influence of marijuana, they're driving under the influence of alcohol and other drugs. And we need to be able to prosecute these people at lower levels of THC. Another issue is with law enforcement, there can be varying levels of time between when they make the stop, the traffic stop, and suspect impairment and get the individual to the hospital to collect a blood sample. And during this time, the THC in their blood is rapidly metabolizing to other metabolites, including that THC COOH that I had mentioned. So if you set a per se level too high, you're going to exclude a lot of individuals who may have been impaired at the time of the stop. And when you get the blood sample, that THC level has decreased rapidly, and by the time it gets to the lab, the levels might be low or might not be detectable at all. A good example of this is a couple months ago I analyzed a case where the officer was able to get two separate blood samples, one on a hospital admission and another blood sample about an hour later, and I was able to detect THC in that first blood sample that was taken, and I was not able to detect THC in the blood sample taken an hour later. So this is also an issue that is facing law enforcement in the crime lab, is the amount of time it takes to get individuals to the hospital for a blood draw. Another reason that setting in a per se level at too high is marijuana impairment can be at its peak despite the low levels of THC in the blood. THC is the number one detected drug in all of the blood samples collected from individuals suspected of impaired driving in Montana. It's surpassed, even categories of drugs. So one single drug has surpassed depressant category, the methamphetamine category. So it's a prevalent drug in Montana, and with growing number of individuals driving under the influence of THC, you don't want to set a per se level so high that you exclude the individuals who are impaired at lower levels. On the other side of the spectrum, the argument is if you have a per se level that's too low, you may include those heavy marijuana users that can carry around residual levels of THC in their system for an extended period of time after they had used the drug. A heavy marijuana user can still show and exhibit impairment at these low levels, but that impairment becomes progressively better and improves throughout the time since the last drug use. So all of these issues have been looked at and studied extensively in the field of toxicology by many scientists and experts, and they have looked at the data and they've tried to come up with recommendations for a science-based per se limit for THC, and they have come up with a level, ranging from 3.5 nanograms per milliliter to 5 nanograms per milliliter, and it is their opinion that this would offer a reasonable separation of unimpaired drivers from impaired drivers, and would hopefully weed out those individuals who may carry around low levels of residual THC for an extended period of time after the drug use. Thank you for allowing me to come speak to you today.
Thank you. Further proponents, House Bill 168.
Good morning, Mr. Chairman, members of the committee. My name is Bill Fulbright. That's Fulbright. I am the Ravalli County Attorney. I wanted to just add a few comments from the perspective of a prosecutor. my thoughts are, if we start with the agreement that it's dangerous for all of our citizens, all of us, if we share the road with someone who is impaired by any substance to the point where they can't multitask, as Trooper Sager was talking about. That's dangerous for all of us. And the second assumption, that we need a mechanism by which to fairly and appropriately enforce our DUI laws in general. This sets a standard by which we can operate in that enforcement to ensure the safety of our citizens, ensure that we don't have to drive down the road with others on the road that are impaired. I guess by way of comment, I appreciate Sarah's her input here. I know that is consistent with the testimony that came before the legislature in the development of the current medical marijuana law, that is the 5 nanograms is the appropriate level. I guess from the working perspective, the issue between the active THC and what's called the metabolite is a non-issue. We deal with that all the time. The metabolites that are in the blood samples that come back are meaningless in the sense of they don't mean anything to us for purposes of impairment for prosecution. So there isn't some confusion floating around out there among the law enforcement community and the prosecution community that we're going to accidentally prosecute someone who only has inactive metabolite. As an example, for years in our youth court, where a youth would be under a court order not to use illegal drugs, they maybe would get a urine test by a probation officer every 15, 20, 30 days. It very frequently in our youth, unfortunately, that are on probation, we would find the inactive metabolite. That means simply that they weren't under the influence when they went into the probation officer, but they used it sometime in the past 25 to 30 days. So that's a well-known concept. So that, first of all, should not set anybody back. That what we're going to be talking about, looking at, prosecuting for is the active metabolite in the blood, which is how an individual is impaired by the THC. We support the amendment that deletes urine and saliva from the testing. It's blood test that's important and relevant to us and what we could prosecute with. We noticed one additional, it's just it would be, I guess, a cleanup amendment, but there's one omission, and that's on page 25, line 20, it's the felony DUI penalties. Section 1 was added to the prior line, but on line 20 there's a list of the prior DUIs, and Section 1 should also be on that line. That as we count the priors to get to the fourth, it would need to have this one added in there. That's a small little cleanup. As a prosecutor, the consistency among laws is important to us because it's how we consistently and fairly and reasonably enforce the law. And I think that this is consistent with the addition of the medical marijuana aspect, the higher number of incidents we see with the use of marijuana involved in driving, and it's a way to consistently and fairly enforce that. By way of additional comment, the Yellowstone County Attorney Scott Twido is in attendance. He had to go upstairs to the Senate Judiciary Committee on another bill, asked me to represent that he was here waiting, and fully supports any law that strengthens prosecution of DUIs also. And I appreciate the opportunity to comment. I'll be here if there's any questions from my perspective. Thank you.
Thank you, Mr. Fulbright. Further proponents?
After Bill testifies, I need to pull the mic down. Larry Epstein, EPSTEIN, today on behalf of the Montana County Attorneys. You heard from County Attorney Fulbright on behalf of his office and County Attorney Twido's office. The county attorneys feel very strongly that as legislators and as prosecutors and on behalf of the law enforcement we represent, that we all have a right to expect safe highways and so do all of our constituents. The fact that people are more and more being pulled over and found to be impaired by marijuana or other drugs is alarming to us. We hope it's alarming to this legislative committee, and we strongly urge on behalf of your own families and our families that you pass this law and at least give us a floor to prosecute on. Thank you.
Thank you, Mr. Epstein. Further proponents?
Mr. Chairman, members of the committee, my name is John Benyon. I represent the Montana Department of Justice. I just wanted to say that the sponsor, we identified this bill about last week, and since then we've been working with the sponsor to make some changes that really, I think, get to some tools that law enforcement can use sound science. And so I wanted to thank him for that. I don't have anything to add to the expert testimony that you've already heard. So the Department of Justice urges you to pass the bill. Thanks.
Thank you, Mr. Benyon. Further proponents?
Mr. Chairman, members of the committee, my name is Jerry Williams, represent the Montana Police Protective Association. And for all the reasons stated, we're strongly in support of House Bill 168. Thank you.
Thank you. Further proponents?
Good morning, Mr. Chairman, members of the committee. My name is Rebecca Sturdivant, Sturdevant. This time I'm representing Mothers Against Drunk Driving and the Montana Common Sense Coalition. I do have a handout. I'm focusing on the second section of the bill, which is victims. Currently, it's very difficult to prosecute under vehicular homicide under the influence without a per se level. And this does not serve our victims well. A good example of this are two of the innocent people killed by DUI drivers on my list on the right. One is Judy Wang, and the other one was Albert Carestes. These people who killed them were under the influence of marijuana and additional drugs, but could not be prosecuted as under the influence. And so I want to really focus on that. My other comment, however, is that I think 5 is an appropriate level for people who are only under the influence of marijuana, but it's not an appropriate level for people who are also under the influence of alcohol or other drugs. I think, Jerry, you might remember back from 2009, Senator Jackson and I brought a bill to the Senate Judiciary Committee in which we requested this per se level, but we also included a second section that the per se level would be lower if there was also other impairing drugs, including alcohol, present. So that would be a recommendation that I would make for an amendment. I've included information about marijuana impairment because as a nurse practitioner and someone who has done research in pharmaceutics, I do have expertise in this area, and I'm very concerned about impairment from marijuana on our highways. You'll notice on page 2 of the second, there's Flathead County Court monitoring. I've been watching a lot of cases in Flathead County over the last 3 years. We're doing better at getting blood specimens now that we have warrant, but for a long time we just had marijuana by report only. You notice the high percentage of cases where there's alcohol and or prescription drugs present. In fact, that's true with low levels of THC also. So I would encourage you to consider that amendment. This bill is very important, not only for public safety, but for justice for the victims of DUI deaths under the influence of marijuana. Thank you.
Thank you, Ms. Sturdivant. Further proponents? Further proponents? Seeing none. Opponents, House Bill 168.
Good morning, Mr. Chairman and members of the committee. My name is Dr. Pat Partis. I am a native of Montana. I practiced chiropractic in the state for approximately 25 years.
Could you spell your last name?
My last name spelled Pardis. I'm here representing the Montana Cannabis Information Association. We do have some problems with this bill in the fact that it has both the active and the inactive substances in it. And I will defer that to somebody else to present some testimony. We've heard a lot here today about the fact that we've seen an increase in marijuana impairment and driving. I would challenge the committee members to look at FBI statistics. Actually, we've seen a fairly steady use of marijuana across the population, not a huge increase. And I would propose to you that the increase that we're seeing in the pullovers here is more due to the teaching of officers to be able to recognize the use of drugs. It's just a matter that we're reporting it more and our officers have the information to report it. So naturally, we're going to see an increase. But I would say if you looked at national statistics, you would see pretty much a flat line everywhere. Marijuana usage is not going through the ceiling like everybody would like to say it is. The other thing I wanted to bring up is that we all know, under impairment of alcohol, that a .08 is arbitrary. I could look at a couple of you in here and we could give you enough alcohol to register .08 and you could walk out of here like you were totally unimpaired. I could give one of you a beer over there and you could be .05, and if that's the first beer you had in 20 years, you might not be able to walk out of here. The point is that .08 is arbitrary. We understand that. We have to pick a number. We understand that. So, understanding that this standard is an arbitrary figure. And the other point I'd like to bring out here is we could save the state of Montana a lot of money. I think what you could do is just take the driver's licenses away of all medical marijuana users. I think we're down to about 8,000 now. So you could just take their licenses away because none of them will probably pass the standard that you've set. I would say also that our number one problem in this country, as the statistics would prove, is prescription drugs. And we need to get impaired drivers off the road from all drugs, from all impairment. And I kind of feel like you're picking on 1 out of 1,000 drugs here that impair people. And if you're really concerned about stopping impairment, then we need to expand this for another 1,000 drugs. I would say that if anybody's been involved with this issue for years, there is a federal organization, NHTSA, that handles these sorts of issues. And they've done a very recent study on impairment of THC. These folks have been the standard for DUI around this country for how many decades, I don't know. The point is, I would really ask all of you committee members to seriously look at this study and see what it has to say about THC and impairment. So with no further ado, I'd like to present to you Rose Habib, who is our scientific expert on this, and she can give you some more information. Thank you.
Thank you, Dr. Pardis. Further opponents?
Hi, I have a handout.
Pass it up.
My name is Rose Habib, Habib. I'd also like to enter in a study from November 2012, statistical study on per se drug driving laws and how it affects traffic fatalities. I'd also like to enter into the record the printout of the website from the National Highway Traffic Safety Administration on marijuana. We all want fewer impaired drivers on the road, and we all want safer roads. We want to set standards for behavior that effectively accomplish that. We want enforceable, equitable, and effective laws that attain these goals. It is becoming more common for law enforcement and therefore legislatures to rely on science as an enforcement tool. And in order to do this effectively, the science must be solid, and we must follow where it leads. We cannot merely enact laws we feel will accomplish a goal when science and statistics say otherwise. The bright line needs to be real and not perceived. With regard to per se driving laws, like House Bill 168, I defer to the study published in November 2012 that I've passed forward. Two economists, one a professor at Montana State University in Bozeman and the other from the University of Colorado in Denver, have compiled data following trends in the number of traffic fatalities in the 16 states, including Washington, with per se drugged driving laws over the past 20 years. Their conclusion is that per se drugged driving laws have no discernible impact on the number of traffic fatalities. Why are we trying to emulate this obviously failed policy? Section 1 of House Bill 168 reads in part, "It is unlawful for any person to drive or control a vehicle while the person's tetrahydrocannabinol level, as shown by the analysis of the person's blood, urine, or saliva, is 5 nanograms per mil or more." By tetrahydrocannabinol, do you mean delta-9 THC, the singular psychoactive component of cannabis, and of the prescription Marinol? According to the National Highway Transportation and Safety Administration, and I quote, "It is difficult to establish a relationship between a person's THC blood or plasma concentration and performance-impairing effects." Many studies have been done trying to establish a relationship between impairment and blood and plasma levels of delta-9 THC, and the data is still inconclusive. On the other hand, there is little to no data on delta-9 THC levels in urine and saliva with regard to impairment. I'm glad to hear that has been removed from the bill. Or by tetrahydrocannabinol, do you mean the 11-hydroxy-THC or the carboxy-THC? These are metabolites most often tested for in urine and blood tox screens. The metabolite is a chemical the blood forms after the body digests the blood, and the presence of these metabolites only indicates past use. It does not indicate impairment or psychoactivity. Carboxy-THC is not psychoactive and can be detected in the blood and urine for over 30 days after a single exposure to cannabis. The National Highway Transportation Safety Administration declares, and I quote, "It is inadvisable to try and predict effects based on blood THC concentrations alone, and currently impossible to predict specific effects based on the carboxy-THC concentrations." Nearly every one of Montana's over 8,000 medical cannabis patients would be guilty of DUI 24 hours a day, 7 days a week, regardless of actual impairment or occurrence of last use. If this is the demographic you are targeting, it would streamline the system to merely withdraw their driving privileges upon joining the registry. But I don't believe that makes our roads safer, and I don't believe that respects our Montana Constitution. The two economists have reported that despite the fact that these laws have been touted by politicians and academics as an effective strategy for making our roadways safer, we find no evidence that they reduce traffic fatalities. This law will make criminals out of people who are not driving impaired. It will cost us more money to prosecute innocent people and will not make our roads safer. Please vote no on House Bill 168.
Thank you, Ms. Habib. Further opponents, House Bill 168. Further opponents, seeing none. Informational witnesses? Seeing none. Questions from the committee? Representative Hill.
Thank you, Mr. Chair. I have a question, I think, it's the same question. I just thought there was two very, very different testimonies. So I think I'll start the question with Mr. Sager, and then it'll be the same question for Ms. Habib, if that's all right.
Certainly.
So, Mr. Chair, Mr. Sager, First of all, thank you very much for your testimony. I thought it was one of the most informational things we heard today. I actually served last session, though, when we heard a lot of DUI legislation. I think that I share probably the views of most of this committee in a bipartisan fashion that the culture of drinking and driving in Montana is an epidemic, and it needs to stop. And I hope we all agree that we aren't going to tolerate it. But that said, like I said, we heard a lot of this legislation last session, bipartisan effort that passed, and this bill, of course, was one of the ones that didn't. And I think it goes back to the questions that I'm going to have for you today, which is, and when I ask you this, please remember I am not a chemist. I'm a lawyer. I've prosecuted a lot of DUIs, but the extent of my knowledge stops at the periodic table. So when you talk, and Ms. Habib talked a lot about active versus metabolized, can you talk a little bit more about that? My understanding is that this bill does not make that distinction, and that there are other states that do. For example, the Washington law that was talked about does make that distinction, and this one does not. So my concern, of course, is if somebody smoked pot 2 weeks ago, would they still have an active? I mean, can you explain all of that? And then we'll have Ms. Habib as well explain it. Did I ask that right?
Oh, yeah, it's right to the point.
Mr. Chair, members of the committee.
Good luck, Mr. Sager.
I'll answer the portion that I can speak to. I'm not a chemist either.
Okay.
I have extensive training in impairment caused by alcohol and drugs, but I'm not a chemist either. So any of that kind of stuff, I will defer to Sarah Brasseth from the Crime Lab. What we are addressing in this bill is the psychoactive, the impairing ingredient in marijuana. We're not talking about the carboxy, as Sarah had stated. And what carboxy is, it is the completely metabolized inactive. It does not cause impairment. What the bill is addressing is the impairing ingredient of delta-9 tetrahydrocannabinol, as it would appear in the blood. Time frames where we're dealing with this is 2 to 4 hours after time of consumption of marijuana. We are not talking days, weeks, up to 30 days after use. We have no interest in the carboxy. Blood samples that we have been receiving from the crime lab for years in driving cases document out both delta-9 tetrahydrocannabinol and tetrahydrocannabinol COOH, or the carboxy. We've been dealing with these numbers forever. That carboxy, as our county attorney stated up here, we're not concerned with that. That just shows past use. It does not cause impairment. Does that answer your question?
It does, yeah, except for, as I said, Ms. Habib's testimony was quite different, so that's why I'm...
Yes, you want to refer...
I appreciate it, thank you.
Ms. Habib, is that what you wanted to do?
Yeah, I guess if she
Ms.
could,
Habib, if you could
sort of answer the same question. Ms. Habib, just to follow up, how does this bill distinguish between active forms of THCs and the ones that have no effect on a person's mental state? I think Mr. Sager answered that this bill does do that, and I guess I got from your testimony that you felt that it didn't.
Mr.
Sorry,
Chairman,
Mr.
Representative Hill, I don't believe that this bill in its current text differentiates delta-9 tetrahydrocannabinol. It merely says tetrahydrocannabinol, which could refer to any of its metabolites or forms. I have in studies, it shows that the level of delta-9 tetrahydrocannabinol peaks actually while the person is still smoking marijuana, and then it rapidly diminishes after smoking. So it's not really, whereas somebody feels the impact of the marijuana, 15 to 30 minutes after smoking, and then loses impact after that. So it's not really a direct correlation between the level of active THC in the blood and impairment.
You have a follow-up, or is that...
Yeah, well, Mr. Chair, with all due respect, do you mind then if we maybe follow up with the woman from the crime lab? Then?
Certainly.
I mean, this really was the crux of the bill last session and why it failed, and so I would like to find out. I mean, certainly we aren't in the interest of prosecuting DUIs of folks that smoked marijuana weeks before.
Yeah, I gave the woman a copy of this just a minute ago, so you can ask her.
Great. So thank you very much for the leeway, Mr. Chair. So, Mr. Chair, and I'm sorry, you're my Missoula crime lab.
Sarah Brassa.
Thank you, Ms. Brassa. So again, our committee, none of us are chemists. This idea of this THC hydroxy, which Ms. Habib was talking about, my understanding is that that does not show that somebody is impaired, THC hydroxy. And so does this bill then distinguish between that, the active forms of THC, and will you help us out here?
Okay. Yes, members of the committee, Chairman, I'll kind of start with saying, so if somebody's using marijuana, like let's say somebody's smoking marijuana, they are ingesting the THC, and so they are getting active levels. So what they're ingesting is that delta-9 tetrahydrocannabinol, which when this bill was presented to us, I believe that was the intention, was to just include the delta-9 tetrahydrocannabinol and not the other metabolites. Okay. So as you're smoking marijuana, you get active levels of THC, the delta-9 tetrahydrocannabinol, in your blood, and your body quickly starts to metabolize that. There's multiple metabolites of THC. You mentioned the hydroxy. So there's an 11-hydroxy metabolite of THC, and that metabolite is actually active. So that's the first time that's kind of been brought up in here. And what Ms. Habib was saying is that there's also a carboxy metabolite, and that's kind of what I talked about in my talk, that THC-COOH is the end metabolite, so it's the last metabolite that the body uses to get it to pass through your system and to leave your blood and urine. So that metabolite is not active, so it would not indicate impairment. So only the delta-9 tetrahydrocannabinol can impair a person.
I'm following you, I think. Thanks a lot, Mr. Chair.
Chairman's going to jump in here,
Thanks,
which
Mr.
I don't do very often, but Ms. Brisseth, while you're there, what I need to see is documentation showing a correlation between the test that you're prescribing here for the active form and impairment. And I need some scientific proof of what we're doing here. This bill died last time because we're getting the legislature ahead of the science, and it's not going to happen again. So if you can show me that the scientific data has caught up and can now detect impairment, I would certainly like to see that. And if it takes you a little while, we'd be happy to hold off on executive action of this bill until we have that. But I'm going to need to see that. That wasn't much of a question. It was more of a statement. But if you could provide that, I would appreciate that. Does that make sense? Do you understand what I'm asking?
Yes. And by that, do you mean as far as just providing you with more studies, more information? Or
you're currently able to test the difference now between an active form and a metabolite. Is that correct?
That's correct.
That's correct, and repeatedly test that without any problem.
Yes.
And so your testimony is that at 5 nanograms per mil of the active form, we have impairment.
And I guess this is where the controversy lies. Okay. Like I said, and it's the same thing with alcohol. We have the per se of a 0.08, whereas an experienced drinker may not show the degree of impairment that an unexperienced drinker will show at that 0.08 level. You have the same issue with marijuana, that at the 5 nanograms per milliliter, an experienced chronic user may not show or exhibit the same signs and symptoms of impairment as an occasional user or a new user of marijuana. The studies out there have just shown that the majority of people at that 5 nanogram per milliliter level are showing some degree of impairment. It's obviously not everybody at the 5 nanogram per milliliter may be deemed impaired, but they're thinking that at that level you're catching the majority of individuals that can show impairment, and you're also including the levels that are dangerous with the combinations of other drugs and alcohol, which have been proven to be at levels 5 nanograms or below in the blood. So to answer your question, I guess in the short way, there's still debate and controversy around that, and the 5 nanogram per milliliter level is kind of like the alcohol at a .08, that you're hoping to catch the majority of impaired people at that level.
Okay, all right, thank you, and appreciate the indulgence of the committee. Let me jump in there. Now I'll get back to the order.
No.
Representative Warburton, you were taken care of. Okay, we have Representative O'Neill.
Question for Sarah again, please. Mr. Chairman, no, Miss
Forsyth.
What? Anyhow, the bill says that the person's tetrahydrocannabinol level is 5 nanograms per milliliter, but it doesn't seem to say their delta 9 THC. Is there a difference?
I guess the common referral to delta 9 tetrahydrocannabinol is THC. So a lot of people don't include the chemical scientific name delta 9 just for confusion reasons. So it is commonly referred to as tetrahydrocannabinol or THC. But there are metabolites that also have the name tetrahydrocannabinol in there, like that THC-COH. The long chemical name of that, I'm sure you guys don't care, but the long chemical name is 11-nor, I might get this wrong, right? The 11-nor delta 9 tetrahydrocannabinol. So it's tetrahydrocannabinol is kind of the base chemical structure. And so when you alter that or change that by making metabolites, you add on other chemical names. So the metabolites have longer chemical names, and I guess the delta 9 tetrahydrocannabinol is just commonly referred to as tetrahydrocannabinol. So maybe in this instance, we maybe need to make a distinction in the bill to include delta 9 tetrahydrocannabinol or include the words active, the active component.
So follow up. So all right,
follow up.
So would you say if we really want to catch the active part of marijuana, we should change that from tetrahydrocannabinol, whatever it is, to delta 9 or something else, a different word to describe the active part of the marijuana rather than what we have the bill has right now?
Yes, and then it wouldn't be as vague, and then if you say delta 9 tetrahydrocannabinol, you're only talking about the active ingredient in marijuana.
Follow up. So could you and your associates come up with an amendment to the bill so we're only talking about the active form rather than the rest of it?
Yes, we could.
Thank you.
Representative Halverson.
For Sarah Brasseth, if I could, please. My question is predicated on what I believe is published in, say, for instance, the PDR, where certain prescription drugs, they talk about a half-life and the rate at which those drugs are metabolized through the body system. Based on that understanding, then, is there a predictable or typical rate at which the active ingredient that causes impairment from smoking marijuana or otherwise ingesting it, is there that half-life consideration that's predictable, or does it vary between individual? And if it is predictable, then can one extrapolate back from, say, for instance, the point of a traffic incident that you could predict or extrapolate back what the blood concentration might have been at the time of the accident?
THC is not like I think you're referring to like alcohol. We commonly know the metabolism of alcohol. There's a common factor out there, a metabolism rate that almost every individual metabolizes. Unfortunately for THC, that's not the case. THC is one of those drugs that can get sequestered in the system and like sitting in the fatty tissues. So unlike alcohol, which can metabolize fairly rapidly, THC isn't the case. What happens is if someone's smoking marijuana, their blood levels of THC spike pretty rapidly, and that peak level of THC that they get to depends on the dose of the drug, so the amount of THC present in that joint, for example, that they are using. It depends on their smoking experience. It can depend on their metabolism. And so that peak level, us as a toxicologist getting the blood report, we'll never know how high of a level they actually got to. So that level rapidly declines. So typically we're seeing, I think when Kurt handed out that chart, the average THC level that we're seeing in the crime lab the past 4 years has kind of been right between 6 to 8 nanograms per milliliter. So after, about an hour, we're seeing levels less than 10 nanograms per milliliter, and then the metabolism from there can slow down and become kind of unpredictable.
I do have a follow-up, if I could, please, then.
Certainly.
So it becomes important that the blood test be taken as close to the incident having occurred as possible. So what's the mechanism then, or what will be the sequence of events that's anticipated when we enforce this law, should it be passed?
I think, it's as officers are being more educated to detect impairment, I think they're getting, noting that, hey, this might not just be an alcohol impairment, there might be drugs present. So they are getting to the hospital a lot faster and getting the blood samples. So I think for them it's important, for these marijuana cases and other drug cases, to get that blood sample as soon as possible so that we can get a more accurate THC level that was going on at the time of the stop.
Thank you. Representative Eck.
Thank you, Mr. Chair. I have a question for Mr. Collier.
Mr. Collier.
That would get the active component of thinking blood.
It was part of the deal. They're going to amend it out.
Mr. Chair, Mr. Collier, I believe I understood you to say in your testimony that a lot of law enforcement officers who are pulling over drivers are not necessarily well trained in recognizing the signs of marijuana impairment, and that DREs are, that's your expertise, so you are able to recognize it much more readily, and so is Trooper Sager. He understands that. But you said that this bill would help with that problem, and I guess I'm wondering, what is the trigger point if an officer pulls someone over and they're not showing signs of being on alcohol, for example, or being impaired by alcohol or other kinds of drugs that are just on marijuana? How would this help them pull the trigger and do blood work? I mean, what is that trigger point if they don't have any other signs of impairment?
Mr. Chair and committee members, maybe I wasn't clear on it. I didn't view it as a huge advantage to the arrest decision because officers throughout the state are trained in recognizing basic impairment. I view it as an advantage in prosecution. And so if I was unclear saying that just having this on the books will help an officer make his decision in the field, I don't necessarily believe that, no.
Okay, follow up, please, Mr. Chair. Okay, Mr. Chair, Mr. Collier, I don't know if you have a copy of the bill, but on page 8, section 6, limitations of the act, it reads, any person, including a registered cardholder, to operate, so this part does not permit any person, including a registered cardholder, to operate, navigate, or be in actual physical control of a motor vehicle, aircraft, or motorboat while under the influence of marijuana, except as provided in subsection 3, the use of marijuana by a registered cardholder. So if someone is actively impaired as a cardholder, are they exempted because they're a cardholder from being prosecuted? Is that what that's saying? And maybe feel free to redirect. I don't know. Maybe Trooper Sager could help me.
I can't speak to how it was drafted, but I could maybe draw a parallel to any other prescription. Just because you have a prescription for Xanax doesn't mean you can be under the influence of Xanax and drive. It's still DUI.
Right.
And we get that as a common objection from people when we arrest them for being under the influence of anything.
Right.
I can probably come up with something where a person said, but I'm 21, I can drink. I mean, I think that's a pretty stale argument at this point. But, that I don't view that as being applicable, but I didn't draft it, and I'd need to defer to somebody else.
Okay. Thank you. Thank you.
Thank you. Representative Regier.
Thank you, Mr. Chairman. I have a question for the witness that passed out the bar graph. Mr. Chairman, Mr. Sager, I don't know if you talked about it, but the title is missing, and I don't know what the numbers stand for on the side. Could you fill us in?
Let me grab my sheet real quick.
Okay.
Okay, these numbers were produced by the crime lab, and perhaps if I'm off, Sarah can address it a little better. These are blood submission cases for DUI drivers. Okay, it includes obviously all blood submission cases, not just cases targeting one category. If you'd like some explanation on what these categories are, I can go into it, but if that answers your question, we can go from there.
That's fine. Thank you.
Representative Wagner.
Mr. Chairman, I have a question for no more than 3 questions. The first one is for Miss Brasseth from the lab.
Ms. Brasseth.
Mr. Chairman, Ms. Brasseth, you were quoting some statistics, 218 THC only cases, and then 39% of those were involved in a vehicle crash. And then you said 19 were fatalities. Was that 19% or 19 cases?
Members of the committee, it was 19 cases.
19 cases.
Follow up. Go ahead.
Redirect to Mr. Sager, please, Mr. Chairman.
Mr. Sager.
Mr. Chairman, Mr. Sager, is there a overall general law that covers convicting people of impaired driving regardless of the cause?
Yes.
Follow-up?
Follow-up.
You mentioned that when there's a combination of THC and alcohol, although they may both be under the legal limits, it causes a magnified impaired effect. Is there any plans in the future to somehow incorporate that for prosecution purposes, to come up with numbers of the combinations levels?
Mr. Chair, members of the committee, to clarify on your question, are we talking more per se?
Yes.
Legislation? I don't draft legislation. With me, impairment, the impairment bill that we have includes all of those cases. And there are, and we've heard this through this one and our synthetic cannabinoids bill that we heard on Monday, the drug world is evolving extremely rapidly. Is there a way that we can tap into all of those? No. Some of those are more prevalent than others. This drug right here is consistently increasing in usage amongst drivers. The stats that we have from the crime lab shows that whether it is detection from law enforcement or an increase in usage, it's obviously a problem if you look at the fatal side of it. I am unaware of it. I don't draft legislation. This is mostly a tool, as Captain Colliard stated, for prosecution and for those cases where we have somebody that's involved in a crash and we cannot use the tools that we currently have readily accessible to us as law enforcement officers, even as a DRE, to determine impairment. If you have somebody that's strapped to a backboard for whatever reason, we cannot run them through the walk and turn, one leg stand. The only thing that we can test is the eyes. And since the indicator that we get in the eyes for marijuana is pupil dilation and rebound dilation, not the horizontal gaze nystagmus that there's all the studies to, officers at that point and prosecution, their hands are tied. The Judy Wang case is the perfect example. Nothing could be done in that case.
Thank you.
Thank you. Representative Fiscus.
I think I'll take Hager because his name's easier to
Mr.
pronounce.
Sager?
Sir, Mr. Chair, sir, I'd like you to just say the arrest procedure. You pull somebody over, and obviously there's impairment there. So what happens next in the process that leads up to even investigating the marijuana as part of the act?
Okay. Mr. Chair, members of the committee, DUI investigation is a 3-step process. Most cases, if the vehicle is in operation, if it is driving down the highway, we have all 3 steps in that process. We have what's called vehicle in motion. That's how we are observing the way that that vehicle is operating. Are they driving in their lane? Are they obeying traffic laws? Are they showing us indicators that the driver is possibly impaired? If we have indicators that they're impaired or there's a violation of law or we suspect that that person is under the influence, we conduct a traffic stop. At that point, we look at how they stop the vehicle, where they stop it, the amount of time it takes, and we compare that to our normal experience or our experience with every other individual that drives down the highway, and that's how we make our determination as to whether they are operating a vehicle safely or not. When we were starting to talk to them, there are indicators. Law enforcement officers are trained observers. It is our job to recognize changes in behaviors. And we deal with people day in and day out, sometimes 5 people in a day, sometimes 30 people in a day. And we have a very good database as to what normal human behavior is. And any time that somebody's operating outside of that behavior, it sends up, for lack of a better term, a red flag. And we start noticing if somebody's having a hard time manipulating their documents because they've lost control of their fine motor skills due to impairment, or they're talking, they're slurring their speech, all these things that we've heard from other aspects of impairment, we proceed on to the next step, which would be pre-arrest screening, where we take them out and we run the individual through our psychophysical tests, which is our eye test, the horizontal gaze nystagmus test. I know these are big fancy cop term words. The walk and turn test, which we've all seen, and the one-leg stand. And those have science behind them. The National Highway Traffic Safety Administration did the studies on those, that they are very good at showing impairment because they determine divided attention things as well. At that point, we make the determination whether we believe the person is under the influence or not, and we proceed on to request a blood sample. As law enforcement officers, we are not randomly taking somebody and going, I think I'm going to get a blood test from you today, and I'm hoping that it's going to show 5 nanograms. We don't operate like that. There's no reason for us to take a blood sample for somebody that we don't believe is under the influence. We have to establish that through a 3-step process that doesn't happen in 2 minutes. Oftentimes with people, it happens in a half an hour of us dealing with that person and detecting these signs and symptoms that we have been trained to detect. Does that answer your question?
Yes.
Thank you.
Just one follow-up question. Mr. Chairman, can I have just one follow-up on that?
Certainly. Follow up.
Yes. Then you determine that, but do you have him blow on a sack or do something to decide right there that you at least got alcohol so far? What do you?
At the conclusion of our psychophysical testing, as we call it, the walk and turn one leg stand, we have them. We request that they administer a portable breath test, our alcohol screening test. Oftentimes, what leads us down the blood path is when that thing comes back and it says 0, or it comes back with a number that's inconsistent with what we're seeing for the impairment. Say the number comes back and it says it's 0.5 alcohol, and this person appears to us to be somebody that we've experienced that looks more like a 1.5 alcohol. The officer's trained to go, that just doesn't make any sense. There's no use going and getting an intoxilizer, another breath sample, because we know there's something that the breath test won't pick up on. Does that answer that?
Yes, and then when this marijuana come into the picture, then how does that come in? Because how does that come into the analysis right there at the highway when you're talking to them? How does that?
On the roadside?
Becomes suspicious.
Okay, through advanced training that we are starting to get across the state, one being advanced roadside impaired driving enforcement, the other being drug recognition expert training. Those officers are specially trained to be able to detect signs specific to certain drug categories. At the academy that all of our law enforcement officers in the state receive, they're detecting impairment. As long as they can prove that they have the impairment, that is what they are trained to detect. And after we get the breath test, they're trained, if it is consistent with the impairment, you go with another breath test. If it's not consistent with the impairment, you go get blood, and we let the other experts that have more training come in and decide whether or help to establish that the impairment was caused by either a combination of drugs or something other than alcohol.
Thank you.
Thank you. Representative Court.
Mr. Chairman, question for Mr. Sager, please.
Mr. Sager.
I was curious to know the number of medical marijuana carriers, the ones that have the medical marijuana card. How many were stopped for impaired driving in those numbers you gave us, or caused those accidents?
That's something that I have not been tracking. I don't know if that's something that our crime lab has been tracking or not. I don't have those numbers right off the bat. I can check with either Sarah here or our other Sarah at the crime lab and see if we have that kind of statistical information. I do have access to a national database that would deal with all the cases nationwide, but the inherent unreliability to that, it's a tracking site for law enforcement, is not everybody is good about inputting their information into that or selecting the box that says this was a medical marijuana case or not. I don't have that information for you at this time. I can try and get that information for later.
Yeah, I'd appreciate that.
Okay.
Thank you.
Thank you. Representative O'Neill.
Thank you. Another question for Sarah Dresa, please. Mr. Chairman, Mrs. Dresa, it seems to me it would be so simple to take a mouth swab rather than a blood test. Why aren't we using that here? Why were we going to amend that out and leave it the blood test?
Mr. Chairman, members of the committee, currently the toxicology saliva testing is inconclusive. It's hard to get a collection device that can look for all drugs and that THC is stabilized in. And for some of these collection devices, you can need a milliliter of spit, and you can imagine how long that would take for somebody that maybe has a dry mouth or something else to sit there and try and collect that much saliva. And they're currently looking at this as kind of, like you said, a less invasive of way for testing for impairment than blood. So it's kind of gaining momentum in the research field. It's just not quite cut up there, and to what levels in the oral fluid would constitute impairment. So it's just the science isn't there, and the collection devices and the procedures for that, they all haven't kind of melded up and meshed yet.
Thank you.
Seeing no further questions, would the sponsor? Did you have? No. Would the sponsor like to close?
Thank you, Mr. Chair, member of the committee, witnesses today. I just wanted to say that it would be open. We would like to get the language cleaned up and make it clear that we're not going after the metabolites. So we're open to that amendment, and I would hope that we could work through John Binion and the Department of Justice for that. The most important aspect of this is to enable prosecution for law enforcement, especially in unfortunate accidents. And Judy Wang is probably the most notable one. This is to protect innocent lives. The way I see this is that no one of us in this room has the right to take a chemical, alcohol, anything, and go out and drive impaired without some guidelines. And I realize that there's some people, like alcohol that we've talked, that they have different effects on it. I know a lot of functioning alcoholics that you can't tell how they are, and it's probably be the same way with this. But we need to set some standard and level to protect the citizens of Montana. I believe with the laws that have recently passed in Washington and Colorado, we're going to see an increase in some of these traffic things. Those people are going to be traveling through Montana. And I just urge this on a public safety thing. Like I said, I am not against medical marijuana, and this is neither pro nor against in my view. This is about protecting the average citizens, children, pedestrians. We've seen some terrible things, and I'm going to let it go with that. And like I said, we're open to amendment to make this work. We want this as a tool for our law enforcement so that they're able to further protect Montanans on the roadway. And with that, I'll close it.
Thank you, Representative Moore. This concludes the hearing on House Bill 168. Committee, we will go into executive action on 3 bills if you want to dig your bills out while the room is turning over, so to speak. We're going to do House Bill 17, 107, and 137. You want to take 5? Okay, we request a quick 5-minute break.
Can we say it
So
again
we'll,
one more time, Mr. Chair?
10:35. Numbers again?
Yeah.